Hey, ladies and gentlemen, I want to share with you some of my experience, and from time to time, I will give you short lectures I title You and the Law. I want to address the issue of defamation today. For there to be defamation, there must be publication of the defamatory words. If the words are in writing, there must be evidence of publication. But it's not all publication that is publication. Self-induced publication is not publication. This was established in the Locus Classicus, Nighthall, and Professor Emmanuel Akonde Tubiele. I was involved in this case from the High Court to the Court of Appeal over a period of 11 years. We won at the High Court, but we lost at the Court of Appeal. Nighthall provided telecommunication services in Nigeria. Nighthall wrote a letter to Professor Tubiele in his private capacity. It was alleged in the letter that he was using fax machines without the authorization of Nighthall. Evidence was given at the High Court that the letter addressed to Professor Tubiele was opened and read by two members of his staff who worked with his consultancy company. At the Court of Appeal, it was held that the two members of staff ought not to have read the letter addressed to Professor Tubiele in his private capacity, and that he had put together a contrivance that enabled members of his staff to read letters that was addressed to him personally. And based on that, we lost at the appeal court. So it's not all publication that is publication for purpose of libel. Self-induced publication will not support a case in libel. You need to read my book on the subject. After that case, I wrote a book, Defamation, Laws, Practice, and Procedure, which is now in this second volume. And in that book, you will find the case Nighthall versus Professor Emmanuel Akonde Tubiele, which was discussed extensively. Thank you for listening to me. I will give you more lectures very soon. Thank you.